Don't do the crime if you can't do the time. That's what we tell ourselves about justice. And for the most part, Americans believe it. That if you follow the law, avoid trouble, and treat others fairly, the system will do the same for you. But if you're an international student in the US right now, none of that is true. Over the past several weeks, hundreds of international students, many of them at major public universities like the University of Illinois, have had their legal status revoked and their futures upended. They weren't convicted of anything. In many cases, they weren't even charged. Some were pulled over for speeding. Some were involved in campus incidents that never saw a courtroom. Others were simply accused of something that was never followed up on. Yet, without a trial, hearing, or explanation, they were expelled from legal status and placed on a trajectory toward deportation. The mechanism is obscure and bureaucratic. The federal government, through ICE and the Student and Exchange Visitor Program, or SEVP, is terminating student SEVIS records, the electronic certification of their immigration status, under vague and unexplained references to criminal record checks. The problem isn't just the termination, it's that students have no way to challenge it. Under normal circumstances, a student whose CVS record is terminated can apply for reinstatement. That process, spelled out in federal regulations, requires the university to issue a special document, a reinstatement I-20, enabling the student to ask U.S. Citizenship and Immigration Services, or USCIS, to review their case. But now universities are refusing to issue those I-20s. Why? Because they're being told not to. SEVP has turned designated school officials, or DSOs, into unwilling agents of immigration enforcement, instructing them, formally or informally, not to assist students in seeking reinstatement. Let's be clear about what this means. The U.S. government is allowing anonymous reports, uncharged allegations, or expunged records to serve as the sole basis for stripping a student's immigration status, and then instructing universities to prevent those students from even asking for a review. This isn't punishment after due process, it's exile by administrative fiat. If this sounds like a Kafkaesque system designed to maximize fear and eliminate accountability, that's because it is. Students aren't being convicted. They're being disqualified by database entries, hearsay, or error, and denied any opportunity to contest those findings. It is now legally and procedurally easier to deport an innocent international student than to suspend a U.S. student for plagiarism. And yet, public reaction has been muted, partly because the apparatus is invisible. There are no headlines reading "Student deported after campus rumor." The official reasons are scrubbed, hidden behind SEVIS termination notices. Even the universities play along, quietly issuing statements that they are unable to assist. But it's time to expose what's actually happening. International students are being denied legal status, not because they broke the law, but because someone, somewhere, said they might have. They aren't being given a day in court, or even a chance to explain themselves to a federal agency. That's not due process. It's administrative erasure. And the most dangerous part? It's scalable. Anyone familiar with how universities operate will recognize how fragile the system is. One call, one unverified complaint, one outdated traffic ticket. In this climate, any of those can become the basis for deportation because there is no requirement that the government prove anything. Just flag a SEVIS record and deny the school the ability to intervene. The entire procedural framework becomes self-enforcing. So, let's dispense with the myth that this is about bad actors or keeping campuses safe. If that were the goal, we'd be looking at convictions and judicial findings. But we're not. We're looking at unverifiable flags in background databases quietly funneled into immigration enforcement mechanisms that offer no appeal and no transparency. The old cliché told us not to do the crime if you can't do the time, but we're now in a far more chilling reality. Don't get accused of the crime, or you may never even be allowed to explain yourself. International students should not be living under a system where anonymous complaints and minor infractions become the functional equivalent of deportation orders, especially when the very institutions they attend are being silenced and co-opted into enforcing those outcomes. DSOs and university leadership need to speak now. Tell the public what instructions you've received. Tell your students why you aren't issuing reinstatement I-20s. Or better yet, start issuing them in protest. Let USCIS adjudicate these cases publicly, transparently, and lawfully. So we can stop pretending this is anything but what it is. A shadow deportation regime built on accusation, not adjudication. If universities are supposed to be bastions of fairness and integrity, this is their moment to prove it. Silence is no longer neutral, it's complicity.